My name is Daniel Sarmiento. I'm a professor of European law at the University Complutense of Madrid. And I was here today in Belfast speaking about criminal justice and human rights. The topic of my keynote dealt with how criminal justice and human rights interact in Europe, and particularly how those interactions take place between the European Court of Human Rights, the Court of Justice of the EU, and national courts. I basically argued that criminal justice is one of the areas of policies in which the different conflicts between legal systems in Europe have been arising lately. It is therefore a very interesting laboratory of how European law, in a very large sense, including EU, convention, national law, interact in ways that allow European integration altogether to become an area of research, but also an area of integration for the peoples and the states in Europe. In particular, I focused on, firstly, how judicial cooperation in the area of criminal justice has been intensifying integration in Europe, but I've also focused on how the interaction between judicial cooperation in criminal law and human rights protection have also created specific areas of friction. In particular, in the case of the European arrest warrant and its implementation, it's been very evident in the case law of the Court of Justice of the EU how the concern about human rights protection has been a reason to introduce considerable restrictions into the way in which the principle of mutual recognition operates when criminal courts cooperate within the EU. At the same time, another important area is the area of substantive criminal law. And I've made the point that in the EU at the time, we are witnessing the creation and the evolution of a supranational criminal law, which is something that has no parallelism in any other international organization. As a result of that, we are witnessing how EU legislation is not only harmonizing criminal offenses, but there is also good proof of how new institutional developments like the European prosecutor will introduce a huge change of paradigm in criminal justice. However, the fact that there is a criminal supranational law in Europe is also creating areas of friction. Mostly that friction is appearing more and more evident between the Court of Justice of the European Union and national constitutional courts. I put the example of the recent saga of Taricco, in which the Court of Justice has been making a case law that has created a lot of conflict and tension in a member state, in Italy, and as a result of a preliminary reference of the constitutional courts in this member state, in Italy, the Court of Justice has been willing to adjust its previous case law in order to facilitate the adjustment between the existence of a criminal supranational law in Europe and human rights protection at the national level. And finally, I referred to the case of accession of the EU to the European Convention of Human Rights. And I made reference to this point because I believe that in the area of criminal justice, it is particularly important that the accession takes place. Not only because it is relevant for the EU to have a clear and precise mandate to comply with the European Convention of Human Rights now that the EU has a very ambitious area of freedom, security and justice, but it's also relevant because the EU is developing more and more instruments to impose sanctions, not only in the traditional field of competition, but also now in the field of banking union, including supervision and resolution, and maybe in the future also in the field of consumer protection. The fact that the EU is an authority that imposes very relevant sanctions on physical and natural persons is another reason so that accession takes place, and that the review made by the Court of Justice is someday also reviewable by the European Convention of Human Rights. And my final point in my keynote has been that criminal justice is not just another ordinary area of policy. It's an area of policy that touches very, very, very intensely on one of the main features of sovereignty, the right to punish punitive powers of the state, which touch, I insist, on crucial points of sovereignty. Admitting that there is a supranational criminal law of the EU means that the EU is willing to assume that very relevant task, which traditionally has been entrusted to the sovereign. Whether we are there yet or not is a question that the future will tell.